A establishment of occupation. Introduction. The military occupation of territory establishes a special relationship between the occupying power and the civilian population of the area, involving, on each side, certain rights and duties. It affects the general administration of the territory, the rights and duties of the inhabitants, and both public and private property. 1. The inhabitants of occupied territory are protected persons and entitled to the protections laid down in Chapter 9. Neutral nationals in occupied territory are entitled to treatment as protected persons under Geneva Convention for whether or not there are normal diplomatic relations between the neutral state concerned and the occupying power. 2. However, neutral nationals not normally resident in but only on a temporary visit to occupied territory can, to a certain extent, claim different treatment from that accorded to the inhabitants in that they are as a rule exempt from requisitions. If their property is required for military needs, they must be compensated or indemnified. 3. Military occupation can assume many different forms. 4. The principal concern of this chapter is belligerent occupation. Classically, this refers to the occupation of enemy territory, that is, when a belligerent in an armed conflict is in control of some of the adversary's territory and is directly responsible for administering that territory. Occupation may, of course, be exercised by 11.1111.1. 1. The rules on occupation are contained in the Hague Regulations 1907, Our, Arts 4256, Geneva Convention for 1949, GC4, Articles 2734 and 4778 and in Additional Protocol 1 1977, API. 2. GC4, Art 4. They have the right to leave the territory unless their departure is contrary to the national interests of the occupying power, see GC4, Arts 35 and 48. For reference to the position of third-party nationals in Kuwait at the time of the Iraqi invasion in 1990, see United States Department of Defense, Report to Congress on the Conduct of the Persian Gulf War, Appendix on the Role of the Law of War, 1992, 31 ILM 612, 617 620. 3. Requisitioning under our, Art 52 is described as from inhabitants and it can be argued that temporary visitors do not meet this description. 4. For further reading, see A. Roberts, What is a Military Occupation? 1984, Bile 249. More than one belligerent, for example in the event of a coalition of forces acting together, and the term occupying power has to be interpreted in relation to that possibility. The term belligerent occupation can also encompass certain other military occupations including, for example, wartime occupation of neutral territory. The provisions of the law of armed conflict that relate to occupied territory apply to belligerent occupations. The present chapter does not cover situations where the military forces of one state are in the territory of another allied state in pursuance of a treaty or agreement between allies. In those cases, the matter is governed by the treaty or agreement. 5. Nor does this chapter apply to cases of international administration of territory, for example by the United Nations or other international organizations, which will usually be governed by a complex of legal instruments establishing and regulating such administrations. In cases of liberation of Allied territory, or in cases where troops are sent into a collapsed state. 6. To restore law and order, it may not always be possible to conclude a civil affairs agreement with the authorities of the country concerned in advance so that there will be de facto military rule by the liberating power. 7. The rules of international law applying to occupied territory should, so far as possible, be applied by analogy until an agreement is concluded. Where a belligerent liberates part of its own territory before normal civil government can be restored, the extent of the military authority's powers is a matter of the domestic law of the belligerent concerned. 8. Definition of occupation. Territory is considered to be occupied when it is actually placed under the authority of external military forces. Occupation extends only to territory where that authority has been established and can in fact be exercised. 9. Effectiveness of occupation. To determine whether a state of occupation exists, it is necessary to look at the area concerned and determine whether two conditions are satisfied. First, that the former government has been rendered incapable of publicly exercising its authority in that area, and, secondly, that the occupying power is in a position to substitute its own authority for that of the former government. Occupied Territory 275 11.12. 5. Such as the NATO Status of Forces Agreement of June 19, 1951. 6. as in Somalia in 1993 or East Timor in 1999. 7. Public Prosecutor VX, Eastern Java, 1948 AD Case No. 176. 8. Batut VR, 1951, Account 519. However, see also Tangent Tuan Vilucia Food Control Board, 1949, 18 ILR 591. 9 hour, Art 42. In some cases, occupying troops have operated indirectly through an existing or newly appointed indigenous government. This type of occupation is not discussed in detail in this chapter. In such cases, despite certain differences from the classic form of military occupation, the law relating to military occupation is likely to be applicable. Legal obligations, policy considerations, and external diplomatic pressures may all point to this conclusion. Patrols, commando, and similar units, which move on or withdraw after carrying out their mission, do not normally occupy territory since they are not there long enough to set up an administration. The use of airborne forces and of mechanized warfare may make it difficult to determine whether occupation exists. When hostilities continue in enemy territory, occupation only arises in areas coming under the control of the adverse party, even if that control is only temporary, provided that measures are taken to administer the areas in question. Occupation does not take effect merely because the main forces of the country have been defeated, but depends on whether authority is actually being exercised over the civilian population. However, for occupation of an area it is not necessary to keep troops permanently stationed throughout that area. It is sufficient that the national forces have withdrawn, that the inhabitants have been disarmed, that measures have been taken to protect life and property and to secure order, and that troops are available, if necessary, to enforce authority in the area. The existence within an occupied area of a defended zone makes no difference so long as it is surrounded and effectively cut off. In cases where two or more states jointly occupy territory, following a coalition military campaign, for example, it is desirable that there be an agreement between them setting out the relationship between the occupying powers. Proclamation of occupation. Mere proclamation of occupation is insufficient to bring an occupation into existence. The test in paragraph 11.3 must be satisfied. Although not strictly necessary in law, a proclamation should be issued to make clear to the inhabitants the existence of the occupation, the area over which it extends, and any special regulations that have been issued by the occupying power. 10-276 JSP 383, Manual of the Law of Armed Conflict. 10 paras 11.25 and 11.58. Commencement of occupation. The occupation starts when the test in paragraph 11.3 is satisfied. Continuation of occupation. Occupation does not cease where the forces of the occupying power continue their advance, leaving only a few troops behind, so long as they have disarmed the inhabitants and made arrangements for the administration of the occupied area. However, the authority of the occupying power should be represented by the presence of a commissioner or civil officials. Termination of occupation. Occupation ceases as soon as the occupying power is driven out or evacuates the area. Occupation will also cease when effective control transfers to a different authority, such that the territory ceases to be under the authority of external military forces. The fact that some of the inhabitants are in a state of rebellion, or that guerrillas or resistance fighters have occasional successes, does not render the occupation at an end. Even a temporarily successful rebellion in part of the area under occupation does not necessarily terminate the occupation so long as the occupying power takes steps to deal with the rebellion and re-establish its authority or the area in question is surrounded and cut off. Whether or not a rebel movement has successfully terminated an occupation is a question of fact and degree depending on, for example, the extent of the area controlled by the movement and the length of time involved, the intensity of operations, and the extent to which the movement is internationally recognized. Applicability of the law of armed conflict. The law of armed conflict applies from the outset of an occupation and continues to apply until the occupation terminates. In Geneva Convention 4, in this chapter referred to as the Convention, there is a provision, the 1-year rule, for some articles of the Convention to cease to apply in occupied territory 1 year after the general close of military operations. However, 43 articles of the Convention continue to apply for as long as the occupying power exercises the function of government in occupied territory. The 1-year rule does not apply to parties to Additional Protocol 1 1977, in this chapter referred to as the Protocol, which specifies that occupied territory 277 the application of the Convention and Protocol shall cease to apply on the termination of the occupation. 11. Since this can result in a complex legal situation, advice about the applicability of international law to occupied territory should invariably be sought from the nearest service legal office. B. General effects of occupation. Temporary nature of occupation. Occupation differs from annexation of territory by being only of a temporary nature. During occupation, the overrealty of the occupied state does not pass to the occupying power. It is suspended. Although there is no specific principle detailing its scope, the ousted authorities may retain some power to make legislation for the occupied territory. This legislation is restricted to legislation that does not conflict with the rights and duties of the occupying power. Must take all measures in its power to restore, and ensure, as far as possible, public order and safety, by respecting, unless absolutely prevented, the laws in force in the occupied state. 12. The law of armed conflict does not confer power on an occupant. Rather, it regulates the occupant's use of power. The occupant's powers arise from the actual control of the area. Prohibition of annexation. Since sovereignty does not pass to the occupying power, annexation of the occupied territory is forbidden. Sovereignty can only pass in accordance with the principles of international law, usually by cession under a peace treaty. Illegal annexation does not absolve a party from complying with its obligations to protected persons under the law of armed conflict. 13. Constitutional position. Since sovereignty does not pass to the occupying power, that power may not change the constitution and domestic laws of the occupied territory nor set aside the rights of the inhabitants except to the extent permitted under the law of armed conflict. 14. Legislative measures may be taken for the security. 278 JSP 383, Manual of the Law of Armed Conflict. 11. The one-year rule is in GC 4, Art 6. For parties to API, see Art 3, B. Our, Arts 42-56 continue to apply for the duration of the occupation. See also, J.S. Pictet, Commentary on the IVTH Geneva Convention, ICRC 1956, Pictet, Commentary on GC 4, 5864. 12. Our, Art 43. 13 GC 4, Art 47. 14. See Paras 11.25-11.29. Of the occupying forces, the maintenance of order, the proper administration of the territory, and to enable the occupying power to carry out its obligations under the Convention for the welfare of the inhabitants. The occupying power may, however, repeal or amend laws that are contrary to international law and is also entitled to make changes mandated or encouraged by the UN Security Council. 15. See resistance to occupation. Before effective occupation. Until the occupation is effective, members of the armed forces of the occupied country, of organized resistance movements, and of a levée en masse. 16. May fight to resist the invading troops. However, they must distinguish themselves from the civilian population by, at the very least, carrying their arms openly during deployments and engagements, otherwise they run the risk of being treated as unprivileged belligerents. 17. After effective occupation. Even after an occupation has become effective, members of the armed forces who have not surrendered. 18. Members of organized resistance movements. 19. And members of internationally recognized liberation movements. 20. May continue the fight, so long as they distinguish themselves from the civilian population or carry their arms openly during deployments and engagements. 21. A levée en masse is not possible after effective occupation. 22. Unprivileged belligerents only combatants have the right to participate directly in hostilities. 23. If civilians take a direct part in hostilities without satisfying the conditions. 11.13. 11.14. Occupied territory 279. 11.12. 15. GC 4, Art 64. These powers may be sufficiently wide to enable repeal of laws, for example, that violate human rights treaties. In relation to UN Security Council mandates, see EGASCOR 1483, May 22, 2003, which inter alia encouraged international efforts to promote legal and judicial reform by the occupying powers and others in Iraq. 16. See Para August 4, 2017 AP1, Arts 43 and 44. For mercenaries, see AP1, Art 47. 18. Surrender of a commander binds members of the armed forces under his command, but not those under other commands, or those serving in allied or foreign forces. 19. GC 3, Art 4, 2, AP 1, Arts 43 and 44. 20. AP 1, Arts 1, 43, 44, and 96. The UK made a statement on ratification of AP 1 that it would only consider itself bound by a declaration of adherence by a body that is genuinely an authority representing a people engaged in a liberation conflict. 23. AP 1, Art 43, 2. Under which they acquire lawful combatant status. 24. They are not entitled to be treated as belligerents and may be punished by the occupying power. However, civilians taking an indirect part in hostilities by, for example, providing information or material, assisting escapers, and hiding weapons could only be punished if they contravened any laws or regulations passed by the occupying power. 25. Unprivileged belligerents are, in any event, entitled to the protection of the Convention and Protocol. 26. Although the right of communication may be forfeited in the case of spies. 27. Punishing protected persons individually or collectively for offences that they have not committed is unlawful, whether or not such punishment is a reprisal measure in response to the activities of unprivileged belligerents. 28. The personal property of civilians is similarly protected. 29d. Duties of the population of occupied territory. Limits of legislative powers of the occupier. The occupying power can create punishable offences in the interests of its security or that of the population in the occupied territory. 30. It cannot compel the population of occupied territory to acknowledge its sovereignty. That means that civilians cannot be required to a. Take part in operations against their own country. 31. b. Assist the war effort of the occupying power against their own country. 32. c. Serve in the armed or auxiliary forces of the occupying power. 33. 280 JSP 383, Manual of the Law of Armed Conflict. 24. CCH 4. 25 C. Paras 11. 25 and 11.28. 26. GC 4, Arts 4, 5, and 68, AP 1, Art 75. 27. GC 4, Art 5, API, Art 45, 3. Under these articles, a state can take more severe measures against an unprivileged belligerent in its own territory than it can in occupied territory. 28. GC 4, Art 33. Also prohibited is the practice of taking hostage prisoners as a deterrent, GC 4, Art 34. The phenomenon of suicide bombing has posed problems regarding the implementation of these rules. In 2002-03, following a number of suicide bomb attacks on Israeli civilians and military personnel, Israel took severe measures in the Israeli-occupied territories against the families of certain suicide bombers. 29. GC 4, Art 53. 30. GC 4, Art 64. See also R. Baxter, The Duty of Obedience to the Belligerent Occupant, 1959. Bile 235, in particular in relation to the obligations of inhabitants, further referred to in Para 11.151. 33. GC 4, Art 51. Nor may any pressure or propaganda be directed at them to enlist in those forces voluntarily. D. Give information to the occupying power about their own armed forces or other defense information. 34. While the orders of the authorities of an occupying power may be lawful, and while the occupant is entitled to require obedience to lawful orders, it does not necessarily follow that failure to comply with such orders is illegal under the law of armed conflict. However, the inhabitants are liable for punishment by the occupying power should they disobey legislation, proclamations, regulations, or orders properly made by that power. Civic duty. In case of necessity, the inhabitants may be called upon for police duty, to assist the regular police in the maintenance of public order, for help with firefighting, or to perform other duties that may be required of citizens for the public good. 35. This rule enables the occupant, in case of necessity, to conscript civilians for ordinary routine public duties, for example, civilian traffic control, provided these duties do not contravene paragraph 11.15. The occupant is responsible for the orderly government of the territory. 36. Rights of inhabitants. The inhabitants must not be deprived, by reason of changes brought about by the occupation, of any of the benefits to which they are entitled under the Convention. 37. The administration of occupied territory. Allegiance. The occupying power is forbidden to compel the inhabitants of occupied territory to swear allegiance to it. 35. The War Office. The Law of War on Land being Part 3 of the Manual of Military Law, 1958, MML 3, Para 545. 36. CGC 4, Art 64. 37. GC 4, Art 47. These rights are set out in Paras 9.21, 9.24 and, in the case of internees, in Paras 9.37, 9.113. 38. Our, Art 45. Administration. The occupying power assumes responsibility for administering the occupied area. 39. Whether the administration imposed by the occupying power is called a military government or civil government is not important. The legality of its acts will be determined in accordance with the law of armed conflict. The occupying power cannot circumvent its responsibilities by installing a puppet government or by issuing orders that are implemented through local government officials still operating in the territory. See paragraph 11.7. Further, an occupying power is also responsible for ensuring respect for applicable human rights standards in the occupied territory. Where the occupying power is a party to the European Convention on Human Rights, the standards of that convention may, depending on the circumstances, be applicable in the occupied territories. 40. Officials, civil servants, police, and judges. General officials of the occupied territory owe no duty of allegiance to the occupying power and may refuse to serve that power. 41. If they have fled, the occupying power will have to form its own administration. Local authority officials who remain may be employed for this purpose. Duties of officials. The occupying power may not alter the status of officials, nor apply any sanctions or take measures of coercion or discrimination against them if they decide to abstain on grounds of conscience from fulfilling their functions. 42. A belligerent cannot compel officials to take part in military operations against their own country, even if they were in the belligerent's service before the commencement of the armed conflict. 43. Those who refuse to serve may, nevertheless, be compelled to do certain types of work. See paragraph 11.5244. Officials will normally be given instructions by their own government whether or not to remain at their posts in the event of occupation. In the 282 JSP 383, Manual of the Law of Armed Conflict. 40. See the decision of the European Court of Human Rights in Bovici and others v. Belgium and others, 2003. 41. ILM 517. 41. GC4, Art 54. See also, Pictet Commentary on GC4, 302-308. 42. GC4, Art 54. See also, Pictet, Commentary on GC4, 302-308. However, see para 11.22. 43. Our, Art 23. 44. GC4, Art 54. See also GC4, Art 51, 2. Absence of instructions. Each must use his initiative. In making their decisions, officials must consider the need to protect life and property. The police should, so far as possible, continue their functions so as to avoid a complete breakdown of law and order. However, they cannot be required to act against lawful combatants, including properly organized resistance movements. Continuity of local administration is important if chaos is to be prevented and the welfare of the population sustained. Dismissal of officials. The occupying power may dismiss officials, including judges, and replace them if they refuse obedience to the occupying power. 45. However, this power should not be used arbitrarily, for example, for reasons unconnected with the official's work, or because of the official's refusal to carry out an order that is contrary to international law. 46. Retention of officials. The occupying power is responsible for paying the salaries of officials who continue to serve if it collects the taxes of the occupied territory. 47. Officials may, as a condition of their being permitted to continue in office, be called upon to take an oath or give an assurance that they will perform their duties conscientiously. The occupying power has no right to demand an oath of allegiance. 48. Offenses by officials. Wrongful acts by officials may lead to their dismissal. Where their acts constitute ordinary crimes, they must be tried and punished according to the laws of the occupied territory. Any act calculated to injure the occupying forces may be dealt with according to security laws previously introduced by the occupying power. 49. Internment may also be ordered in the interests of the security of the occupying power. 50. The law. The law in force. There is an obligation during the occupation to respect the laws in force in the occupied territory unless absolutely prevented. 51. An occupying power. Occupied territory 283. 11.22. 45. GC4, Art 54. See also Pictet, Commentary on GC4, 302-308. 46. See the cases of the German military courts in Greece, 1943-45 AD Case No. 149, also, R.V. Morghami et al., 1946 AD Case No. 139, MP, Batavia, v. Mrs. S. Badog, 1947 AD Case No. 118. 51. Our, Art 43. Would be prevented from respecting the laws in force if they conflicted with its obligations under international law, especially Geneva Convention for 1949. The occupying power is not obliged to use the full powers available under the laws in force in occupied territory. It may suspend any of those laws that affect its own security, for example, those concerning conscription, electoral enfranchisement, rights of public assembly, the bearing of arms, and the freedom of the press. The right of the inhabitants to take legal action in the local courts must not be affected. 52. The occupying power may amend the existing law of the occupied territory or promulgate new law if this is necessitated by the exigencies of armed conflict, the maintenance of order, or the welfare of the population. 53. The domestic law of the occupying power, apart from that affecting its own armed forces, does not extend to occupied territory. Since the occupying power has a duty to look after the welfare of the inhabitants, regulations, for example, fixing prices and securing the equitable distribution of food and other commodities, are permissible. The occupying power should make no more changes to the law than are absolutely necessary, particularly where the occupied territory already has an adequate legal system. Jurisdiction. The courts of occupied territory retain jurisdiction to deal with any of the inhabitants' cases that are neither of a military nature, nor affect the safety of the occupying forces. Jurisdiction in the latter two cases is a matter for the authorities of the occupying power. Members of the occupying forces and their civilian component are normally not subject to the jurisdiction of the local courts but remain under that of their own military authorities. 54. Local courts. The local courts may be suspended only if necessitated by the judges or magistrates' refusal to act or on account of the behavior of the inhabitants. In those circumstances, the occupying power must establish and duly publicize its own courts. Local courts, where functioning, have an obligation to enforce the proper laws and orders of the occupying power, but before doing so are entitled to determine whether those laws and regulations are within the competence of the occupying power under international law. 284 JSP 383, Manual of the Law of Armed Conflict. 54. All states are under an obligation to try persons who have committed grave breaches of the Geneva Conventions. In theory, both the local courts and those of the occupying power would have jurisdiction to try members of the occupying forces for grave breaches. In practice, jurisdiction in those cases would usually be exercised by the occupying power. Publication of measures. The suspension, modification, or replacement of law or courts must be published to the population of the occupied territory in their own language. Criminal law. The special rules of the Convention dealing with the administration of criminal law in occupied territory are dealt with in paragraphs 11.56 to 11.74. The economy. Occupation costs. The economy of an occupied country can only be required to bear the expenses of the occupation, and these should not be greater than the economy of the country can reasonably be expected to bear. 55. Taxation. If the occupying power collects taxes, duties, and tolls which were payable in the occupied state, it is bound to apply them towards the cost of administering that territory. 56. As far as possible, it must do so in accordance with the existing tax laws, but any balance may be applied towards the maintenance of the occupying forces. However, local rates may only be used for the purposes for which they were levied. If tax officials continue to work normally, taxes will be collected by them in the usual way. Otherwise, the occupying power may impose an obligation on each local authority to collect and pay a proportion of total revenue. The occupying power can levy contributions from the inhabitants, which may only be applied to the needs of the occupying forces or to the administration of the territory, and only insofar as those requirements are not met by existing taxation. Funds raised must not be used for the enrichment of the occupying power or its personnel. 57. Nor be used as a collective punishment. 58. Contributions from towns and productive areas may be used to support poorer areas. Contributions may only be collected on the written order of the Commander-in-Chief of the occupying forces. Generally, fundraising must accord as far as possible with the system for assessing taxes in the occupied territory. A receipt must be given to each individual contributor. Occupied Territory 285. 11.28. 55. Judgment of the International Military Tribunal sitting at Nuremberg, trial of the major war criminals before the International Military Tribunal, IMT, Vol 22, 482. Commerce. The occupying power may place on the occupied territory such restrictions and conditions in respect of commercial dealings as may be necessary for military purposes. For the same reasons it may remove existing restrictions, such as current customs tariffs. Currency. The occupying power's own currency may be used in addition to that of the occupied territory. Currency regulations may be issued by the occupying power. These measures must be necessitated by the situation in the occupied territory and must not be for the purpose of enriching the occupying power or damaging the local economy. It follows that attempts to debase the currency or impose artificial exchange rates would be unlawful. The occupying power may also issue vouchers for use by members of its forces and civilian component in the occupying forces' installations, shops, and canteens. Security measures. Censorship. For legitimate reasons of security only, censorship may be imposed on the press, films, radio, television, theaters, and public entertainment, or to limit or prohibit telegram, postal, or telecommunications. To the same extent, existing press laws need not be respected. The publication of newspapers may be prohibited or subjected to restrictions, and the distribution of newspapers to unoccupied parts of the country or neutral countries may be stopped. Postal facilities. Subject to the exigencies of the armed conflict, existing postal services must be permitted to continue. The occupying power is not obliged to provide postal facilities for the inhabitants except in accordance with specific obligations under international law, such as, for example, prisoner of war and internee mail, relief consignments, communications with the protecting power, and the ICRC. Transport. All means of transport, whether public or private, come under the authority of, and so may be regulated by, the occupying power and are subject to requisitioning. 60. 286 JSP 383, Manual of the Law of Armed Conflict. 60. Hour, Art 53. See paras 11.82 and 11.90. Restrictions on civilians. Although the occupying power can impose various restrictions on civilians, including restricting freedom of movement within the occupied territory, forbidding changes of residence, visits to particular districts or immigration, and may require the possession of an identity card, these are all subject to the safeguards set out in the Convention. 61. Protected persons. 62. Who are not nationals of the state whose territory is occupied have the right to leave, subject to similar conditions and procedures as those under which they would be entitled to leave the territory of a belligerent. 63. Internment or assigned residence. If other measures are insufficient, and it is required by imperative reasons of security, civilians in occupied territory may be placed in an assigned residence or may be interned. 64. Such action must accord with procedures prescribed by the occupying power and the requirements of the Convention set out in paragraphs 9.31 to 9.36. Appeals. The prescribed procedures must include a right of appeal. Appeals are to be decided with the minimum of delay, decisions being subject to periodical review, if possible every 6 months, by a competent body set up by the occupying power. Financial support. Persons subjected to assigned residence orders and required to leave their homes must be given an opportunity, subject to the interests of security, of finding paid employment. If they are unable to support themselves and their dependents, the occupying power must ensure that they are supported and must permit them to receive allowances from their home country, the protecting power, or relief societies. Religion. Public worship must be permitted by the occupying power and religious convictions respected. 65. Ministers of religion being permitted to give spiritual assistance to members of their religious communities. The occupying power must also accept consignments of books and articles needed for religious purposes and facilitate their distribution within the territory. 66. GC 4, Art 58. If the salaries of the clergy are paid by the state and the occupying power collects the taxes, it must continue to pay them. 67. Children, education and schools. Schools and other educational establishments must be permitted to continue their ordinary activities. 68. The occupying power must, with the cooperation of the national and local education authorities, facilitate the proper working of schools and other institutions devoted to the care and education of children. In certain circumstances, an occupying power may be within its rights in temporarily closing educational institutions, but only when there are very strong reasons for doing so. These reasons are made public, and there is a serious prospect that the closure will achieve important and worthwhile results. Children. The occupying power must do all that it can to facilitate the identification of children. 69. And registration of their parentage. A special section of the National Information Bureau must be given responsibility for identifying children whose identity is in doubt. Particulars of their parents or other near relatives must always be recorded, if available. The personal status of children may not be changed and they may not be enlisted in formations or organizations controlled by the occupying power. If local institutions are inadequate, the occupying power must make arrangements for the maintenance and education of children who are orphaned or separated from their parents and who cannot adequately be looked after by relatives or friends. Persons entrusted with the maintenance and education of children must, if possible, have the same nationality, language, and religion as the children. Any measures introduced prior to the occupation in favor of children aged under 15 years, expectant mothers, and mothers of children under 7 years in respect of food, medical care, and protection against hostilities must not be obstructed by the occupying power. 70. Medical care and hygiene. Responsibility of occupying power. The occupying power has a responsibility for the medical care of the inhabitants of occupied territory. 71. It must ensure, so far as possible, that existing hospitals, medical, public health, and hygiene services in the 288 JSP 383, Manual of the Law of Armed Conflict, 71. GC 4, Art 56, AP 1, Art 14. Territory are continued. It has a special responsibility to prevent the spread of disease. The medical and health authorities and personnel of the occupied territory must assist in this process. It follows that medical personnel of all categories must be allowed to carry out their duties. In doing so, the occupying power must take account of the moral and ethical standards of the population. If the occupying power sets up and operates new hospitals, they are entitled to protection from attack and to display the protective emblem. 72. Medical transports and personnel are similarly protected. 73. The occupying power may issue such regulations as are necessary for compliance with its obligations under this paragraph. Requisitioning of medical units. The occupying power must not requisition civilian medical units. 74. Their equipment and personnel as long as they are needed for the treatment of civilians. If not, they may be requisitioned provided that a. It is necessary to do so for the adequate and immediate treatment of military wounded and sick. B. Requisitioning only lasts as long as the need continues. C. Immediate arrangements are made to ensure that the medical needs of the civilian population, as well as those of any wounded and sick under treatment who are affected by the requisition, continue to be satisfied. 75. Food and other essential supplies. The occupying power is bound to ensure, to the fullest extent of the available means, that the civilian population are supplied with food, medical supplies, clothing, bedding, means of shelter, other supplies essential to their survival, and objects necessary for religious worship. 76. If the resources of the occupied territory are insufficient, these items must be supplied by the occupying power. The occupying power must not requisition. 77. Food, medical supplies, or other articles in occupied territory except for use by the occupation forces and their civilian component, and then only if the needs of the civilian population have first been taken into account. Receipts must be given for requisitioned property and a fair price paid. 78. The protecting power must be given the opportunity at any time to verify the state of the food and medical supplies in occupied territory, subject to any temporary restrictions imposed by imperative military requirements. These provisions are intended to prevent economic exploitation of occupied territories. Relief schemes. 79. If the whole or part of the population of occupied territory suffers from a shortage of supplies, the occupying power must agree to relief schemes being put into operation. Such schemes must be implemented without delay, the occupying power facilitating them by all available means. 80. Relief schemes relate particularly to the provision of food, medical supplies, and clothing and may be undertaken by neutral states. 81. Or impartial humanitarian organizations such as the ICRC. All parties to the Convention and Protocol must permit the free passage of relief supplies and guarantee their protection. A state permitting the passage of relief supplies to territory occupied by an adverse party is entitled to search the consignments, regulate their passage according to prescribed times and routes, and be reasonably satisfied, through the protecting power, that the consignments are to be used for the relief of the population of occupied territory and not for the benefit of the occupying power. 82. Diversion of relief supplies. Relief supplies may only be diverted from the purposes for which they were intended, with the consent of the protecting power, in cases of urgent necessity and in the interests of the population of occupied territory. 83. Diversion of relief supplies might be necessary if, for example, an epidemic ceased in one area but spread to another, or if insuperable difficulties prevented supplies from getting through to the original destination. Distribution. The cooperation and supervision of the protecting power must be sought with regard to the distribution of relief supplies. If the protecting and occupying powers agree, this responsibility may be delegated to another neutral state, the ICRC, or other impartial humanitarian body. The occupying power must facilitate the rapid distribution of relief consignments. 84-290 JSP 383, Manual of the Law of Armed Conflict. 81. Although GC4, Art 59, refers to states, Pictet, commentary on GC4, 321 suggests that only neutral states are capable of providing the essential guarantees of impartiality. AP1, Art 70 is capable of more flexible interpretation. Taxes, duties, and costs. In occupied territory, relief supplies must be exempted from all charges, taxes, or customs duties unless these are essential to the economy of that territory. All other parties to the Convention and Protocol are required to do their best to permit transit and transport of relief supplies to occupied territories free of charge. 85. Relief personnel. The provisions of paragraph 9.12 apply equally to relief personnel in occupied territory. 86. Individual relief. Unless there are imperative security reasons to the contrary, the occupying power must also permit protected persons in occupied territory to receive individual relief consignments. 87. Relief societies. Subject to temporary and exceptional measures imposed for urgent reasons of security by the occupying power, the latter has a duty to permit recognized National Red Cross and Red Crescent societies and other similar organizations to continue their humanitarian activities in accordance with established principles. The occupying power may not acquire any changes in the personnel or structure of these societies that would prejudice their activities. The same principles apply to non-military organizations that are already in existence in the occupied territory, or which may be established, for the maintenance of essential public utility services, distribution of relief, and organization of rescues. 88. Labor. Permitted work. Protected persons aged 18 years and over who are not interned may be required by the occupying power to do work necessary for the occupying forces, the public utility services, or the feeding, sheltering, clothing, transport, or health of the population of the occupied country. 87. GC4, Art 62. An example would be a civil defense organization, see also AP1, Art 63. 88. GC4, Art 63. 89. GC4, Art. 51. See para 9.77 in respect of internees. To meet the needs of the occupying forces or for the administration of occupied territory, the occupying power may enlist the aid of the local population in such capacities as, for example, engineers, doctors and nurses, clerical staff, carpenters and builders, butchers, bakers, and lorry drivers. Employees of railways, haulage contractors, airlines, canal, river, tug, and shipping companies, telephone, postal, and broadcasting authorities may also be enlisted. So too may laborers involved in repairing roads, bridges, or railways, those involved in the burial of the dead or the removal of refuse. Refusal to do permitted work may be punished if the occupying power first passes legislation to that effect. Prohibited work. The following types of work are prohibited. 90. A. Compulsory service in the armed forces of the occupying power. 91. B. Compulsory work by persons under 18 years. C. Compulsory work involving participation in military operations. D. Work outside the occupied country of which the workers concerned are nationals. E. Employment in organizations of a military or semi-military character. G. Any other work outside the categories listed in paragraph 11.52. Protected persons may not be compelled to use forcible means to ensure the security of installations where they are performing compulsory labor. 92. Nor may they be compulsorily employed in, for example, the construction of military defenses or airfields, the production of munitions, the movement of military supplies, or the laying or lifting of minefields. Conditions of work. As far as possible, workers should remain in their usual places of employment and be paid a fair wage. The work must be appropriate to their physical and intellectual capacities. The legislation in force in the occupied territory concerning working conditions such as wages, hours of work, equipment, training, and compensation for occupational accidents and illnesses continues to apply. 93. Contracts and regulations may not prevent workers from seeking the assistance of the protecting power. Measures 292 JSP 383, Manual of the Law of Armed Conflict. 90 GC4, Art 51. See Para 9.77 in respect of internees. 91 This is a grave breach of GC4, see Art 147. 92 GC4, Art 51. Except, to some extent, for police duties, see Para 11.21. 93 GC4, Art 51. See Para 9.77 onwards in respect of internees. Aimed at creating unemployment or restricting opportunities so as to induce people to work for the occupying power are prohibited. 94. Deportation and movement of civilians. The occupying power is forbidden to transfer forcibly or deport protected persons from an occupied country either to its own territory or to that of any other state. Members of the occupying power's own civilian population may not be transferred to occupied territory. Protected persons may not be detained in an area that is especially exposed to the dangers of armed conflict, unless the security of the population or imperative military reasons so demand. An area may be totally or partially evacuated by the occupying power if a. Such evacuation is required either for the security of the population or for reasons of imperative military necessity, and b. Protected persons are not moved outside occupied territory, unless there is no alternative, and c. The evacuees are returned to their homes as soon as hostilities in the area have ceased, and d. To the greatest extent practicable. 1. Proper accommodation is provided, and 2. Movement takes place under satisfactory conditions of hygiene, health, safety, and nutrition, and 3. Members of the same family are not separated, and the protecting power is informed of transfers and evacuations as soon as they have taken place. 95. Unlawful deportation or transfer is a grave breach of the Convention. 96. Administration of criminal law. Continuation of criminal law. During the occupation, the existing criminal law of the occupied territory remains in force. It may be amended, suspended, or repealed by the occupying power only if it constitutes a threat to security or impedes compliance with international law. To the same extent, the courts of occupied territory may continue to administer the criminal law. Power to enact new legislation. The occupying power may introduce new criminal laws as necessary to enable it to fulfill its international obligations, maintain orderly government, and ensure the security of the occupying power, its forces, administration, establishments, and lines of communication. 98. Publication of new legislation. New criminal law enacted by the occupying power comes into force only after it has been duly published to the inhabitants in writing in their own language. It must not be retroactive. 99. Competent courts. The occupying power may set up its own non-political, military courts to try offences created by its own legislation. These courts, sometimes known as occupation courts, are in addition to the existing criminal courts and others that have to be established by the occupying power to administer the law of the occupied territory if officials and judges have left their posts. Occupation courts must sit in the occupied territory. So, whenever possible, should courts dealing with appeals from occupation courts. 100. The rule set out in paragraph 11.59 prohibits the occupying power from extending its own civil court system to occupied territory. The occupation courts may consist of either military or civilian judges, but they must be responsible to the military authorities of the occupying power. If they are authorized to do so in accordance with laws made by the occupying power, these courts may also try cases of alleged war crimes. 101. All of these courts are subject to the rules set out in paragraphs 9.6 and 11.60 to 11.74. Applicable law. Occupation courts may only apply those provisions of law applicable at the time of the commission of the offense and which accord with general principles of law and with human rights guarantees in the occupant's law and human rights instruments by which the occupying power is bound. 102. In the absence of more specific rules, the principles in the Universal Declaration of Human Rights 1948 will apply. In particular, the penalty must be proportionate to the offense. Courts must also take into account the fact that the accused is not a national of the occupying power. Prosecution of nationals of the occupying power. Nationals of the occupying power who, before the outbreak of hostilities, sought refuge in the territory of the occupied state, must not be arrested, prosecuted, convicted, or deported from the occupied territory, except for offences committed a. after the outbreak of hostilities, or b. before the outbreak of hostilities which, according to the law of the occupied state, would have justified extradition in peacetime. 104. Notification of proceedings. The protecting power must be informed of all proceedings brought by the occupying power against protected persons and involving possible sentences of imprisonment for 2 years or more or the death penalty. 105. It is entitled to have information at any time about the state of such proceedings and also to obtain full particulars of any other proceedings brought by the occupying power against protected persons. Notification of cases involving the death penalty or imprisonment for 2 years or more must reach the protecting power at least 3 weeks before the date of the first hearing and must include the following particulars. A. A description of the accused. B. The place of residence or detention. C. Details of the charge or charges and particulars of the law or laws alleged to have been violated. D. Details of the court that will try the accused, and E. The date and place of the first hearing. 106. Rights of defense. Accused persons are entitled to the following. A. Prompt written notification, in a language that they understand, of the particulars of the charges against them. 107. B. Personal presence at the trial including the facility to present necessary evidence for the defense, calling witnesses as required. C. Assistance by a qualified advocate or counsel of their choice who must be able to visit them freely and have all necessary professional facilities for preparation of the defense, and 105. Death sentences may not be imposed by UK courts. D. An interpreter to assist both during the preliminary investigation and at the trial, together with the right to object to the interpreter at any time and to ask for his replacement. 108. If the accused fails to choose an advocate, the protecting power may provide one for him. If the protecting power is not functioning and the accused faces a serious charge, the occupying power has a duty to provide an advocate or counsel, subject to the accused's consent. 109. Avoidance of delay. The accused shall be brought to trial as rapidly as possible. 110. Bar to trial. Before the trial can commence, evidence must be submitted at its opening that due notice was given to the protecting power. 111. Procedure at trial. Sentence may not be pronounced until the accused has been properly tried. The minimum requirements of a proper trial are set out in paragraph 9.6. 112. Attendance of the protecting power at trial. Representatives of the protecting power have the right to attend the hearing, unless it is held in camera for security reasons. In that case, the protecting power must be notified of the fact and of the place and date of trial. 113. Punishment. The following rules on punishments must be observed. A. Protected persons who commit an offense aimed only at harming the occupying power, but not amounting to an attempt on the life or limb of members of the occupying forces or administration, a grave collective danger, or a cause of serious damage to the property of those forces, their administration or installations, are subject to the maximum punishment of internment or simple imprisonment, provided that the duration of such internment or imprisonment is proportionate to the offense. 114. B. Military courts of the occupying power may, at their discretion, convert a sentence of imprisonment to one of internment for the same period. 112. GC 4, Art 71, AP 1, Art 75, 4. It is a grave breach to deprive willfully a protected person of the rights to a fair and regular trial. See GC 4, Art 147, AP 1, Art 85, 4, E. 113. GC 4, Art 74. The reference number of the pre-trial notice should be given. C. The death penalty may only be pronounced. 116. 1. In respect of offences against laws introduced by the occupying power where the accused has been convicted of espionage, serious acts of sabotage against military installations of the occupying power, or intentional offences which have caused death. 117. 2. On a protected person if the attention of the court has been drawn to the fact that the accused is not a national of the occupying power and, therefore, owes it no duty of allegiance. 118. 3. On a protected person who was aged 18 years or over at the time of the offense. 119d. Protected persons must not be arrested, prosecuted, or convicted for acts committed or for opinions expressed before the occupation or during a temporary interruption of the occupation. 120. And E. Any period spent under arrest by the protected person while awaiting trial or punishment has to be deducted from any sentence of imprisonment. 121. The reference in subparagraph A to internment or simple imprisonment does not preclude non-custodial penalties, such as fines, not involving the loss of an individual's liberty. Some breaches of legislation made by the occupying power, even if not intended solely to harm that power, may also be punished by internment or imprisonment, since they adversely affect the orderly government of the territory for which the occupying power is responsible under the Convention. Examples of such offences include contravention of regulations on blackout, curfew, traffic or exchange control. 122. Notification of outcome of trial. The protecting power must be notified of any sentence of imprisonment for 2 years or more or of death and of the grounds for that sentence. The notification must refer to the pre-trial notification and, in the case of imprisonment, must identify the place where the sentence is to be served. 123. Appeals. Although a convicted person has no specific right of appeal under the law of armed conflict, a right of appeal may exist under the law applied by the court. Even where that law makes no provision for appeal, the convicted person has a right to petition the competent authority of the occupying power in respect. 116. A death penalty may not be pronounced by a UK court. 117. GC 4, Art 68 continues with the proviso that such offences had to have been punishable by death under the law of the occupied territory in force before the occupation began. 119. GC 4, Art 68. For death sentences on women, see para 9.82. 120. GC 4, Art 70. This does not apply to violations of the laws and customs or war. 123. GC 4, Art 74. Of finding and sentence. He must be fully informed of his rights of appeal and of any time limits within which he must present his appeal or petition. 124. Time limits for appeals. Any time limit for appeals in cases of death sentences or imprisonment for 2 years or more does not begin to run until the notification of the judgment has been received by the protecting power. 125. Death sentences. Death sentences may not be imposed by United Kingdom courts, nor may United Kingdom service personnel or officials assist in any way in the implementation of death sentences, for example, by other states or by local courts. For states whose laws permit death sentences, the following rules of the Convention apply. Persons sentenced to death may not be deprived of the right to petition for pardon or reprieve. Death sentences may not be carried out before at least 6 months have expired from the date of receipt by the protecting power of notification of final confirmation of the death sentence or of any order denying pardon or reprieve. The 6-month period may, however, be reduced in particular cases in circumstances of grave emergency involving an organized threat to the security of the occupying power or its forces. But even so, the protecting power must be notified of the reduced period and must be given a reasonable time and opportunity to make representations to the occupying authorities about the death sentence. 126. Record of judgments. A record of all judgments must be maintained by the courts and made available for inspection by representatives of the protecting power. 127. Treatment of detainees. Protected persons who are detained either because they are awaiting trial or as a result of a custodial sentence are entitled to have the following treatment. A. Their sentences must be served in the occupied country. B. Their accommodation must, if possible, be separate from that of other categories of detainee. 124 GC4, Art 73, AP1, Art 75, 4, J. Denial of the right of appeal would be a violation of the International Covenant on Civil and Political Rights 1966, Art 14, unless a specific derogation had been made under Art 4 of that covenant. C. Their conditions of food and hygiene must be sufficient to keep them in good health and must not be less favorable than those in force in prisons in the occupied country. D. They must have the medical attention required by their state of health. E. They have the right to spiritual assistance. F. Women must be kept in separate quarters from men and under the direct supervision of women. G. Minors must be looked after appropriately. H. Detainees have the right to be visited by representatives of the protecting power and the ICRC. I. Detainees have the right to receive at least one relief parcel per month, and J. Detainees have the right at the conclusion of the occupation to be handed over with relevant records to the authorities of the liberated territory. 128 F. Enemy property in occupied territory. Destruction prohibited. Any destruction of enemy property, whether it belongs to private individuals or the state, is prohibited unless the destruction is absolutely necessitated by military operations. 129. Extensive destruction and appropriation not justified by military necessity and carried out unlawfully and wantonly is a grave breach of the Convention. 130. There is no unrestricted right to seize and take enemy property of every kind. This part of this chapter deals with the question of enemy property in occupied territory. 131. Private property. Respect for private property. Private property must be respected. Requisitions must be proportionate to the resources of the occupied territory and limited to the needs of the occupying power. 132. Seizure is limited to certain types of property, see paragraphs 11.77 and 11.81. 131. For the protection of civilian property on the battlefield, see paras 5.23-5.25, for the treatment of property taken from prisoners of war, see para 8.25, and for the treatment of internees' property, see para 9.43. Private property includes not only what would be regarded in common parlance as private property but also property, regardless of ownership, which is dedicated to religion, charity, education, or to the arts or sciences. 133. The requirement to respect private property is subject to conditions necessitated by armed conflict. For example, military operations inevitably cause damage to private property and occupying forces are entitled to requisition property for necessary military purposes. Nevertheless, the principle of respect is important. Nothing is more subversive of military discipline than plundering or looting. Theft and robbery remain punishable crimes in peace and war. 134. The soldier in an enemy country must observe the same respect for civilian property as he would at home. Permanent seizure of land and buildings, whether belonging to private individuals or to corporations, must not be appropriated or otherwise disposed of, nor even used, leased, or hired for private or public profit. This prohibition also protects the private property of ruling families, so long as it is private and not the property of the state. 135. Temporary use of land and buildings. Land and buildings may be used temporarily for the needs of the occupying power, even if that use impairs its value. Military use would include, for example, use for quartering, construction of defensive positions, or for the accommodation of the wounded and sick. Buildings may be used for observation, reconnaissance, cover, and defense. If necessary, houses, fences, and woods may be cleared to open up a field of fire or the materials used for bridges, roads, or fuel imperatively needed by the occupying forces. The owner of property used in this way may claim neither rent nor compensation, but, if possible, a note of the use or damage should be kept or given to the owner so that, if compensation becomes available at the close of hostilities, there will be evidence to support the claim. If, however, a private owner has been compelled to accommodate troops or the sick or wounded in his home, this constitutes requisitioning for which payment should be made. 136. Quartering of troops. When troops are quartered in private accommodation, some rooms should be left for the inhabitants who should be evicted only if that is imperatively 300 JSP 383, Manual of the Law of Armed Conflict. 134. Hour, Art 47, GC4, Art 33. See also NDA 1957, SS5, 35A, AA 1955, S30, and AFA 1955, S63. 135. Previously dealt with in MML3, Para 591. 136. Elohim, International Law, 7th edn by H. Lauterpacht 1952, Vol. 2, 411. Dictated by military necessity. In that event, some effort should be made to give the inhabitants notice and facilities for taking essential baggage with them. When unoccupied buildings are used, care should be taken of the structure and the internal fixtures and fittings. An owner's absence does not excuse theft or damage. If items are taken for military purposes, a note should be left to that effect. 137. Reprisals. Reprisals against the property of protected persons are prohibited. 138. Seizure of movable property. All private movable property used for the transmission of news or to transport people or goods, whether by land, sea, or air, and private arms or munitions of war, may be temporarily seized but must be restored to the owners when peace is made. 139. The peace treaty will also deal with the question of compensation for property that has been lost, destroyed, or damaged. 140. Submarine cables connecting an occupied territory with a neutral state may only be seized or destroyed if that step becomes absolutely necessary. In that event, they have to be restored, and arrangements for compensation made, when peace is made. 141. Items falling within paragraph 11.81 include cables, telegraph and telephone equipment, buses, trucks, cars, trailers, railway rolling stock and other such equipment, ships in port, river and canal craft, aircraft, arms, munitions, and all kinds of property that could serve as war material. That includes raw materials such as crude oil. Arms and ammunition includes sporting weapons owned by civilians. Medical transports are excluded. Method of seizure. The law of armed conflict does not specify in detail the exact form that notifications of seizure should take. Administrative effort at the conclusion of hostilities will be reduced if a detailed receipt is given at the time of seizure. Requisitioning of private property. The occupying force may requisition commodities and services needed for its maintenance. Requisitioning must take into account the needs of the civilian population. 140. Hour, Art 53. However, the obligation to pay compensation is not dependent on a peace treaty. Commodities that may be requisitioned include food and fuel, liquor and tobacco, material for uniforms and boots. Although alcoholic liquor and tobacco may be regarded as luxuries, they are included amongst the sorts of items that may be requisitioned since they would provide an element of comfort to occupying forces. The status of other luxury items like jewelry can be distinguished on the basis that they are not needed by such forces. The authorities of the occupying power must always act in good faith in requisitioning, whether for the needs of the occupying forces or for the needs of the civilian population. Exploitation of the economy of the occupied territory and private enrichment are forbidden. The occupying power has a duty to ensure the provision of food and medical supplies for the civilian population and maintain orderly government. If the resources of the occupied territory are insufficient, the occupying power must import the necessary supplies. If, for example, large stocks of food and medical supplies were stored in private ownership, perhaps to force up prices or distort the economy, the occupying power could not reasonably be expected to contribute or import goods from its own resources. To avoid the absurdity of the occupying forces having to release their own stores for the civilian population, only to requisition others from the civilian population for their own use, it would be lawful for the occupying power to requisition or order compulsory sales at proper prices of hoarded foodstuffs, medical supplies, and other essential items needed for the civilian population. Method of requisitioning. Requisitioning may only take place on the authority of the commander in the locality occupied. If possible, goods and services should be paid for immediately. Otherwise, a receipt must be given and subsequent payment made without undue delay. 143. Requisitioned goods become the property of the occupying power. Local authorities may be asked to assist in procuring supplies, but, if this is impossible, special units, under an officer, should be detailed for the purpose. Supplies may be requisitioned in bulk or, alternatively, local inhabitants may be required to complete a return giving details of quantities in their possession of which a proportion may then be requisitioned. Householders on whom soldiers have been quartered may also be required to feed those troops. The prices to be paid for requisitioned supplies and for commodities on sale may be regulated by the local commander. 302 JSP 383, Manual of the Law of Armed Conflict. Public property. Military land and buildings. Military land and buildings belonging to the state, such as supply depots, arsenals, dockyards, and barracks, as well as airfields, ports, railways, canals, bridges, piers, and their associated installations, remain at the disposal of the occupying power until the end of the conflict. Structures of this type may only be destroyed or damaged if that is imperatively demanded by military operations. 144. Civilian land and buildings. Land and buildings that belong to the state but that are essentially civilian or non-military in character, such as public buildings, land, forests, parks, farms, and coal mines, may not be damaged or destroyed unless that is imperatively necessitated by military operations. The occupying power is the administrator, user, and, in a sense, guardian of the property. It must not waste, neglect, or abusively exploit these assets so as to decrease their value. The occupying power has no right of disposal or sale but may let or use public land and buildings, sell crops, cut and sell timber, and work mines. It must not enter into commitments extending beyond the conclusion of the occupation, and the cutting or mining must not exceed what is necessary or usual. 145. Land and buildings of local authorities. Exceptionally, the property of local authorities, including, for example, that of provincial, county, municipal, and parochial authorities, is treated as if it were private. Similarly, property of institutions dedicated to religion, charity, education, art, and science is also treated as private property, even if it belongs to the state. The seizure, destruction, or damage of such property, historic monuments, and works of art or science is forbidden. 146. Examples of buildings in this latter category include places of worship, almshouses, hospitals, schools, museums, and libraries. If it is cultural property, it is protected anyway. 147. Use of property mentioned in paragraph 11.87 for other, humanitarian purposes, such as the treatment of the wounded and sick in a church, is quite proper if suitable alternative accommodation cannot be found. Cultural property is not to be used for military purposes. Public movable property. Occupying forces may only seize three types of movable property belonging to the occupied state. A. Cash, funds, and negotiable securities which are strictly the property of that state. 149b. Stores of arms and supplies, means of transport, and other movable property which can be used for military operations, together with appliances for the transmission of news, wherever situated. 150c. Public revenue and taxation raised in occupied territory, although the consequence is that the occupying power becomes liable for the costs of administering the occupied territory. 151. It is the actual appropriation of such property, rather than mere occupation, that transfers ownership to the occupying power. 152. Since the seizure of funds in the hands of banks but belonging to private individuals or corporations is not permitted, banks should not be ordered to part with funds and securities until their ownership has been determined. Other public movable property. Other public movable property, not of use for military purposes, must be respected and not appropriated. 153. Official documents and papers connected with the armed conflict may be seized, even if they are part of official archives, because they will be of military significance. However, other types of archival documents, as well as crown jewels, pictures, and art collections may not be seized. Property of questionable ownership. Where there is any doubt about whether property found in the possession of the enemy is public or private, as may occur in the case of bank deposits and stores and supplies obtained from contractors, it must be considered to be public property unless and until its private character is clearly shown. However, account should be taken of difficulties of proof of ownership, for example, if records have been destroyed or are unavailable. Where a public authority holds property on behalf of a private individual, for example, private bank deposits in state-owned banks, the property must be regarded as private. Where both public and private interests in property exist together, 304 JSP 383, Manual of the Law of Armed Conflict. The occupying power may seize or confiscate the property but must compensate private individuals to the extent of the value of their interest. General devastation. Extensive destruction not justified by military necessity, particularly of things indispensable to the survival of the civilian population, including food, agricultural areas, drinking water installations, irrigation works, and the natural environment, with a view to denying them to the civilian population or the adverse party is prohibited and may amount to a grave breach. 154. The cumulative effect of this is to ban the type of general destruction known as a scorched earth policy in occupied territory. The distinction between prohibited general devastation and permissible destruction necessitated by military operations is one of fact and degree to be determined in each case.
Debt Free TV, in association with GetOutOfDebtFree.org.